Hi, I'm Emily, and I'm here with Maya Murphy's attorney, Eva Marie Franco Fox. Attorney Fox practices at Maya Murphy's Westport, Connecticut office and is admitted to practice law in both Connecticut and New York. My question today for Attorney Fox is there a way for me to determine if my prenuptial agreement is enforceable before I file for divorce in Connecticut?
That's an interesting question, Emily. The way that we commonly see disputes over contracts play out in Connecticut is that the parties will enter into a contract. They'll generally abide by the terms of that contract for some period of time, and eventually a dispute will arise. The parties may have a different interpretations as to what their rights and obligations are under the contract, or perhaps one party is alleging that the other side has violated the contract or breached terms of the contract. And often the breach is the result of these two different interpretations of what their rights and obligations are under the contract. And so eventually, if the parties can't resolve the difference in interpretation or resolve their dispute, it can escalate to litigation, and the parties can spend years litigating before they can go to trial and get a court order that would clarify what are their actual rights under the contract and what is the proper interpretation of the terms of the contract that they're fighting over. However, while this is how these kinds of issues commonly play out in Connecticut, it's not how they have to play out. Connecticut and actually several other states have a mechanism in place that allows parties to seek a judicial determination of what their rights or obligations under contract may be without having to actually formally litigate the issue for years and years in a contentious case. This in Connecticut is called seeking a declaratory judgment. A declaratory judgment, as I said, is a legal determination. It's made by a court, and it provides clarity as to uncertainty surrounding a legal issue. It can advise on whether or not a contract is enforceable or certain provisions of a contract are enforceable, and certainly clarify what the rights, duties, and obligations of the parties to a contract are. Now, while a declaratory judgment is legally binding in Connecticut, it's not the same type of order that you would expect that you would get if you were litigating in a divorce in family court. So, for example, two parties have a prenuptial agreement, and that prenuptial agreement contemplates that party A is going to buy out party B's interest in the marital home in the event of a dissolution of marriage. A declaratory judgment would generally specify what the obligations are. So it could, for example, say, yes, in the event of a dissolution, party A, your obligation would be to buy out party B from the marital home. It's not ordering party A to then go forth and buy out party B. It's simply saying this would be your obligation in the event of a divorce. Whereas in the context of divorce litigation, that court order is not only going to specify what party A's obligations are, but it would generally then order party A, yes, now you have this period of time, 30 days, whatever the agreement dictates, to go and buy out party B's interest. So there's a distinction here. One is simply clarifying rights, whereas generally within the context of litigation, it wouldn't just be a clarification, but it would be parties to then go comply with the terms of the agreement. So the declaratory judgment is a mechanism that can be used in pre-litigation or hopefully to prevent litigation. It can help the parties in a quick, efficient, and cost-effective manner determine what their rights and obligations are, and perhaps that will inform them as to whether or not they do actually want to proceed with a divorce now that they understand what the consequences could be for the divorce, at least financially, or help them determine maybe they need a modification of their prenuptial agreement, maybe they need a postnuptial agreement. It can help clarify what their obligations are under their prenup, and perhaps realize we need to renegotiate this. This isn't what we intended this at one point, but we don't intend it now, or there was a misunderstanding of what the actual agreement dictated. Now, this can also be used as a tool within the divorce context for individuals who perhaps want to get divorced, but they want to do so amicably. Maybe they're going to mediation. Maybe they're going to use the collaborative approach. But they have this issue of fighting over whether or not the agreement is enforceable, or fighting over what their obligations are under the agreement. Seeking a declaratory judgment is a cost-effective and quick way for them to get clarity on this legal issue without having to take a divorce case all the way to trial, and still have time to then go to mediation or sit down at a conference table and try to resolve the issues amicably. So certainly, a declaratory judgment likely is underutilized within the family law context, but it's a tool that can really help parties evaluate if they need a modification, or evaluate how to proceed in divorce settlement negotiations, either with or before divorce, or within the context of an actual divorce case that's ongoing. So if you have any questions about the enforceability of your contract, or you have any questions about whether or not you're in a position to seek a declaratory judgment to be armed for some kind of settlement negotiations, or try to modify your agreement, feel free to contact our firm. We're happy to discuss this with you.